Thank you very much for joining me in this video. I want to talk to you today about non-refundable deposits. Again, it was brought to my mind by an issue that came up recently. One of the salespeople was working on a commercial transaction, had a lot of moving parts. There were some problems with it. The seller was operating a business within the bricks and mortar. He was selling the bricks and mortar, but he wasn't selling the business. And so in order to complete the transaction, he'd have to close down his business, he'd have to move his inventory, he'd have to take down some of his trade fixtures and so on. And if the buyer didn't go ahead and close the transaction, he had some exposure. He couldn't start the business again, he's dismantled what he had, so he wanted to make sure that he was safeguarded. Well, it came time for the condition to be removed, and the buyer requested more time, wanted an extension. And the seller said, well, hold it. Before I do that, because of my exposure here, I want you to increase the size of the deposit, and I also want you to make it non-refundable. So he wanted to sign back that it would be non-refundable. And we need to understand his reasoning. His reasoning was there was some exposure here, and he needed some protection, and maybe he was losing a little bit of confidence in the buyer. When we talk about releasing a deposit, and as you know, real estate firms hold the deposit in trust. And we're told by the registrar that we can release the deposit if one of three things happen. The transaction completes, and then for it's no longer trust funds, we can release the money, or we get a signed mutual release signed by both parties directing us as to where the deposit goes, or we have a court order. And without one of those three things, the money sits in trust and we can't release it. Well, the problem crops up if the deal does not close, there goes that option, and one of the parties or the other refuses to sign a mutual release. That creates a problem. And the question always comes up, or often comes up, why do we even need a mutual release at all? Right in the clause, the condition in the offer, there's an automatic built-in mutual release. It'll say that it's conditional on financing, or conditional on satisfactory inspection, whatever it might be. And then it says, failing which this offer shall become null and void, and the purchase deposit shall be returned to in full with an interest or penalty. So right there we've got the direction. Why can't we just release the money? Well, the question is good faith. That's the challenge. The buyer is saying, look, if I can get my financing, I'll buy your property. And then he can't get the financing, he wants his deposit back. But the seller says, I don't think you were acting in good faith, especially if after the fact, the guy goes ahead and buys a more expensive property. I remember I was dealing with a first-time buyer, a fairly sophisticated gentleman. He was an engineer, and he put an offer in years and years ago, and then he changed his mind. He just flat out changed his mind. Well, the seller suspected that, and the seller said, I don't think he really tried. I don't think he was operating in good faith. So I went back to the buyer and said the seller's not going to sign a mutual release, and here's the reason why. So the buyer went to the bank and got a letter from the bank saying he was turned down on his application for his mortgage. I talked to the bank manager. So I said, I'm sure I do my homework. This guy was more than qualified for the mortgage. And the bank manager says, I'm not going to give a mortgage to somebody who doesn't want one. But the point was the seller was challenging it. Or we've had situations where it's conditional on property inspection. And it says at his sole and absolute discretion, there comes back, there's a few minor things, it's not a new property, and the seller says, oh, I don't mind, I will fix that. And the buyer says, no, I'm walking away. Well, the seller says, I'm not sure you're operating in good faith. So because of this good faith issue, the registrar takes the position, even though in the agreement of purchase and sale on the condition clause, it says failing which deposits refunded or returned. The registrar says if either party challenges it, you can't be the judge and jury. It has to go before a judge. You can't release the deposit. So we're caught in the middle. So what's come along is this concept of non-refundable deposits. And what the idea of a non-refundable deposit is, doesn't matter. Regardless, if this transaction doesn't close, the money's going to go to the seller. The seller's got some exposure, as it was in this case, and the seller says, if it doesn't close, I want the money. Well, it sounds good in principle, and it says without a mutual release, it's built right in. It not only has the mutual release in the clause, but we're saying we're doubly fortifying it by saying non-refundable. Well, What happens though if the reason it didn't close was because there's a cloud on title and it couldn't close? Does that mean that the buyer forfeits his deposit? Well, not then. That's what the clause says. Or what happens if the seller wasn't acting in good faith? Should the buyer be penalized because the seller didn't do what he promised to do? Well, probably not. So we ran into a situation here, and what lawyers try and do is they try and draft a clause that will overcome our reluctance to release a deposit in spite of what the registrar says. And this was the clause that the lawyer provided me last week. In the event that the buyer does not close on the date fixed for closing for any reason, and then he added, other than the default by the seller, the deposit shall be forfeited to the seller, and the deposit holder may release the deposit to the seller without further direction, in other words, without a mutual release, or by liability to the buyer and without court order. So they're trying to circumvent that. And the said deposit shall be retained by the seller as liquidated damages and not as a penalty, without prejudice to the seller's right to avail himself of all applicable remedies pursuant to the agreement of purchase and sale and at law for any damages suffered. So, he says, there you go, carte blanche. You got to release the deposit. You don't have to have a court order. You don't have to have further documentation and other mutual release. Sounds good. So I had a conversation with the lawyer, and I said, you've got in there, except by default by the seller. Who makes the decision whether the seller's in default? I said, what happens is it doesn't close on the day of closing, and the buyer says, the seller promised to leave the premises in broom-swept condition. He didn't, so I'm not going to close. The seller says, I want the deposit. You should have closed. The buyer says, no, you're in default. The seller says, no, I had my paperwork ready. We're ready, willing to close. And the buyer says, yeah, but you didn't fulfill your obligations. So we're right back to the same thing we would have been back with before, where RICO would say, you can't be the judge and jury. It's got to go before a judge, and so you can't release a deposit. Well, we're caught in the middle. And this is why I don't like this non-refundable deposit clause in an agreement of purchase and sale. We hold the deposit. And because we hold the deposit, unless it's dual agency, the client is the seller. And the client's saying to us, Wayne, release the deposit. And I'm saying, I'm sorry, I can't. And the seller is saying, it says right in the contract that you'll release the deposit. And I'm saying the buyer, who's not my client, the buyer is saying, you weren't acting in good faith. You weren't ready to close. It was your fault, not his. Well, it wasn't my fault. We're caught in the middle, so it has to be resolved by somebody other than us, even though it says non-refundable. So what it means is it's going to have to go to the courts. Well, what will likely happen is we, as the brokerage holding the deposit, are going to get named in a lawsuit. The seller's going to sue for the deposit. He's going to sue the buyer, but he's also going to sue us because we're holding the deposit. So what we'll do is we'll apply to the courts or to RICO to have them hold the deposit, let them get involved in the lawsuit. We can step out. But there's still some legal meandering that takes to take place. And the question I might ask is, I'll say to the buyer, when they're drafting up this agreement of purchase and sale, would you feel comfortable if the deposit was going to be held by the seller's lawyer in trust? Oh, I don't know that I like that. Why not? It's a non-refundable deposit. Or what about, why don't you just give the seller the money? And we'll say on closing, it's going to apply against the purchase price. Well, I wouldn't want to do that. Yeah, but that's what the intent here is when you're signing non-refundable deposit. You're saying regardless of what happens, seller's going to keep the money, so why not give it to him now? Those seem like extreme positions, but if it seems like extreme position to the buyer needs to think twice about signing this non-refundable clause in the agreement, and make sure if you are involved in the transaction and that term non-refundable deposit is in the agreement of purchase and sale, make sure the parties know it isn't simple as they might think it's going to be. Thank you very much for taking your time. Look forward to talking to you again next week.